afternoon, everybody. Welcome to today's HR exchange on safe exits and settlement agreements. My name is Alex Herwood. I'm an employment solicitor and head of employment at Bayani Law. And I'm joined today by Hasti Ascani, who's an employment lawyer at Bayani Law, and she's going to be doing some of the presenting as well. So just a quick note, this session will be recorded and shared publicly. Please be mindful not to share any confidential information in the main session. If you would like to discuss anything confidential with us, then please just email us at hello@bayanilaw.co.uk. If you have any questions throughout today's session, please just pop them in the chat box and we will aim to answer as many questions as we can. If we run out of time, just make a note of your question and email it to us and we'll get back to you as soon as possible. So just a little bit about the HR exchange. So this is supporting employers across the entire employee lifestyle. So the HR exchange network offers you an opportunity to gain some valuable advice and information from employment solicitors and HR professionals, as well as a chance to share your experiences with us. With your peers in various industry sectors. This is just the on screen now. It just shows the reviews. So we've been very proud of our reviews and our 5-star reviews that we get at Bayani Law. And just on screen now gives you an example of what we do at Bayani Law. So we can do everything from recruitment all the way to termination and litigation and anything else in between. And we also offer bespoke training courses as well. Right, let's make a start. So today we're going to be talking a lot about settlement agreements and exiting employees. So when we discuss settlement agreements, it's important that we remember that they are often used in situations where there's a potential dispute arising from a dismissal or proposed termination of employment. So before an employer decides to dismiss an employee, we've got to ensure that there is a potentially fair reason to dismiss. And we know that, don't we? So under the Employment Rights Act 96, there are 5 potentially fair reasons. So the first one is conduct. So where the employee has done something that's inappropriate or unacceptable. And this can be anything such as misconduct or repeated misconduct or gross misconduct. We have capability. So that's when the employee is not able to do their job or does not have the right qualifications. So this could involve poor performance, kind of ill health, or if the employee is lacking kind of necessary skills, qualifications, aptitude to carry out the job. We have redundancy, which unfortunately is very common at the moment. So when the job is no longer needed. So yeah, where the employer's need for the employees to carry out that work of a particular kind has reduced or ceased altogether. Redundancy is about kind of the role disappearing, not the individual. And that's something you always need to bear in mind. And employers must follow that fair consultation and selection process. The next reason is a legal reason. So quite simply, that's when the employee cannot do their job legally. So for example, you know, a lorry driver has been banned from driving. Obviously, what can you do? You're a lorry driver, you can't do your work. So, you know, that's a legal reason for dismissal. And there's some other substantial reason, which is a term that's used for kind of a wide range or wide variety of situations. So that might be kind of an irretrievable breakdown in working relationships, or a business reorganization that doesn't necessarily end in a redundancy. So we have to bear in mind those 5 fair reasons for dismissal. So what is a settlement agreement? So we know that it was formerly years ago called a compromise agreement. It is not called a compromise agreement anymore. It is a settlement agreement. It must be legally binding. So in most cases, the settlement agreement will provide the termination of employment on agreed terms, although they can be used during ongoing employment to settle existing disputes. So the employment doesn't have to come to an end. Confidentiality is an absolutely key feature here, and the parties will usually agree to keep both the terms of the agreements, the circumstances leading up to the dismissal, strictly confidential. Payment, so we know this typically kind of includes, salary up to a termination date, accrued but untaken holiday, notice pay where applicable if they're not working it, and in many occasions an additional ex gratia compensation payment in exchange for the employee waiving their rights to pursue any claims against the employer. So that compensatory consideration payment. We're also conscious that a settlement agreement can end claims. So a settlement agreement brings to an end almost all employment-related claims that employee could otherwise pursue. So this provides both parties with that kind of certainty, finality. It avoids that time, that cost, that uncertainty of employment tribunal litigation, which we know can be such a burden on resource and on people mentally. Finally, settlement agreements are often offered on a without prejudice and or a protected conversation basis. Now, we're going to come to that in a little bit more detail later on, so you can understand those concepts a little bit better. So, why do we use a settlement agreement then? So, like I've said, it ends nearly all ongoing and potential legal claims. So it's a clean break for both parties. It protects the employer from not only these employment tribunal claims, but it also protects from county court claims and other legal action. There are some exceptions, but that's generally the position. It will set out what you expect from your employee up to the termination date, such as garden leave, the requirement for handover, what will happen with their benefits, such as their company car or life insurance, etc. So it kind of sets out the stall as to what's going to happen leading up to that termination date. You can stipulate that the circumstances leading up to the agreement and negotiations of the terms of the agreement are kept strictly confidential. Again, there is exceptions to this, which we will touch on, but it effectively allows you to exit that employee quietly. And also in voluntary redundancy situations. So without a fair and reasonable redundancy process, it's not a reason for dismissal. So an employee cannot volunteer to leave without resigning if you make a VR, voluntary redundancy, make someone voluntarily redundant without a settlement agreement. You're effectively dismissing them as an employee. So you've not gone through that process. So what we would always urge you to do is, right, okay, you're going down the VR route, right? Okay, let's make sure we put some settlement agreements in place just to cover you. And we'll discuss at what point in the process a settlement agreement will be effective. It's a useful tool in sorting out workplace disputes where termination is a preferable solution. And it's important to bear in mind that sometimes a relationship has just simply run its course. And an employee needs or wants to move on, but needs a little bit of encouragement to do so. So that settlement agreement sometimes can be very helpful in those situations because they'll be effectively getting a little bit more money, an ex gratia payment, which might kind of, push them to make that decision. So really importantly, we need to have a think about what cannot be settled by a settlement agreement. Okay, so I know this was some time ago and it started, this movement started, but following the Me Too movement and the rise in both awareness and claims of discrimination and harassment, in 2018, the Women in Equality Select Committee published a report on workplace sexual harassment and made a series of recommendations, including suggesting a potential new legislation governing the acceptable use of confidentiality clauses, or sometimes called non-disclosure agreements. And the government responded, condemning the misuse, their misuse, and particularly where they're used to kind of cover up that workplace harassment or intimidate victims into silencing them. And it's also unacceptable that the use of confidentiality clauses fail to tackle repeated offenders and perpetuates unacceptable workplace an unacceptable workplace culture. So what we do know, in accordance with the Employment Rights Act 25 from one of the reforms from April 26, is that disclosures relating to sexual harassment are also expressly protected, and we'll talk about that a little bit more. And this is, reflecting the increased focus on ensuring that victim is not kind of prevented from reporting unlawful conduct. So what else can't be settled? Pension claims can't be settled. So you'll often see in an agreement that it'll say, you're not prohibited from pursuing any claim in respect of accrued pension rights. And this is because the trustee of the pension scheme owes the duty of care to the employee, and they're not generally a party to the agreement. PI claims are also, you're also not able to settle latent PI claims. So those that have arisen, after the date of the agreement, which the employee wasn't aware of at the date of signing. Protected disclosures. This is also an important one. So I've just touched upon the sexual harassment now becoming able to amount to a protected disclosure. That also includes protected disclosures. Also includes criminal activities, safeguarding, health and safety breaches, financial impropriety, anything which is serious and would fall within the kind of public interest. GP consultation claims. We can't contract out of a failure to inform and consult claim under GP. These can, however, be settled by way of an ACAS COP3. Okay, so you can settle them, it's just a different route. And also we know that we can't contract out of statutory maternity, paternity, adoption pay, etc. Many of you will already be aware that if you dismiss a pregnant employee after her qualifying week, then she will be entitled to the full SMP, and this can be paid in a lump sum under the settlement agreement. All right, so let's just dig a little bit deeper into this whistleblowing then. So like I've said, it's important to remember that there are certain disclosures that cannot be prevented by a settlement agreement or confidentiality clauses, okay? And these are known as protected disclosures under whistleblowing legislation. An employee must always retain the right to report matters such as criminal offences, breach of legal obligation, etc., and including sexual harassment. So, like I've touched on before, a significant development is that, as of April 26, disclosures relating to sexual harassment are also expressly protected. And this has had a direct impact on how settlement agreements and confidentiality clauses are drafted. So whilst the majority of employment tribunal claims, including sexual harassment claims, continued to settle before the final hearing, employers and advisors, HR, must ensure that confidentiality provisions are lawful, proportionate, and enforceable. Okay, so in particular, a non-disclosure agreement must never suggest that an individual is prevented from reporting criminal conduct, for example, making a protected disclosure, or cooperating with the police or regulators, or, for example, participating in legal proceedings. Any clause seeking to do so is likely to be unenforceable, okay, and it could expose those involved in drafting those settlement agreements to regulatory consequences. So we just need to be so careful the way in which they are drafted. The Solicitors Regulation Authority, the SRA, has also issued specific guidance warning solicitors not to draft NDAs that threaten consequences which cannot legally be enforced. So solicitors must not seek to prevent individuals from reporting offences, and like I said, giving evidence in legal proceedings. They must also ensure that individuals are permitted to retain a copy of their settlement agreement. The SRA also reminds us as solicitors that individuals bringing harassment claims may be particularly vulnerable. So we need to bear that in mind. Solicitors, employers, HR should therefore avoid applying kind of undue pressure during negotiations or including terms that seek to take unfair advantage of unrepresented or vulnerable individuals. So these are all things we have to be bearing in mind when it comes to drafting. All right, so we're just going to have a quick look at this scenario. So this is a kind of a typical turn of events. So you have a member of staff with 7 years service who's been off sick for 5 months with work-related stress. Before they went off on sick, you were planning on starting a disciplinary process where you were unsure whether you would have enough evidence to dismiss. You've been following your sickness absence policy, and you've been supplying fit notes, and they have been supplying fit notes to confirm their reason for the absence, but they've refused to attend any welfare meetings or have any discussions. You can't see how they can return to work anytime soon. And the question is this a suitable situation to offer a settlement agreement? And if it is, how would you go about doing this, and what factors do you need to consider? I'm not sure whether anyone wants to contribute. I can go on to the next slide. Does anyone want to have a go answering that question? Or would you just like me to go on to the answer? I'll go on to the answer. Okay, so what would we normally consider then? So assuming that we've decided that the settlement agreement is a realistic option, and it could be, there are questions we'd want to work through before advising the employer to proceed, because it could be very risky. So first of all, we have an employee who's on the sick. Could this give rise to disability discrimination? Yes, quite possibly. This is always my starting point. The employee's been absent for 5 months with work-related stress. So we know the employer that could give rise to, diagnosis of anxiety, depression. So has that employer obtained an occupational health report? Do they understand the medical prognosis? Could this amount to a disability for the purposes of the Equality Act? So that's got to be really at the forefront of your mind here. If that employee is likely to be disabled, have you put in place those reasonable adjustments? Have they been explored? And I'd also be asking myself other questions. So if the employee rejected the settlement agreement tomorrow, could I confidently defend a capability dismissal? And that's what you need to have in your back of your mind, because obviously it's their prerogative if they want to turn it down. What have you done? Have you done things properly? If the answer is no, then more work probably needs to be done before approaching the settlement. Okay, so it's just important timing. Secondly, where are we with this disciplinary process? Okay, so the scenario tells us, doesn't it, that the employer was considering disciplinary action, but wasn't sure whether that evidence was strong enough. So this actually makes a settlement agreement more attractive, because litigation obviously carries that significant risk. But it also means we are more likely to satisfy the requirements for a pre-existing dispute. Or alternatively, we're going to rely on the protected conversation provisions under Section 118 of the Employment Rights Act. However, we must not use a settlement agreement simply because we don't want to investigate properly. We've got to have that dispute. Thirdly, how are we going to go about approaching it? Okay, so and this can be a bit of a tricky one. So ideally, the settlement discussions are held face-to-face or via video call. That gives you the opportunity to explain that this is just simply a proposal. There's no obligation to accept it. And if the employee declines, normal procedures will continue. But in this scenario, we know that the employee has refused all communication. So in practice, it might be entirely reasonable to write to them instead, and closing, an offer letter, or without prejudice decision in principle letter, together with the proposed settlement agreement. I would tend to send the letter first to see whether they're interested in it. We'll come to that in a minute. So if you are meeting face-to-face, preparation is always critical. So who's going to attend? Where's that meeting going to take place? What's the wording we're going to use? Because we're going to be feeling a bit uncomfortable, because we're going to be effectively having this without prejudice conversation. Obviously we're going to be ignoring phrases such as, accept this or you're dismissed, or giving them an ultimatum. Instead, this is kind of you need to be explaining that this is an opportunity to explore whether an agreed exit is preferable for both parties, because they might bite your hand off for it, but you just don't know. So you tread in very carefully. So this is an important one. So should you send the invitation letter or the settlement agreement as well? There isn't really a correct answer. It's fact sensitive. It depends on what's happening with that employee. If the terms have already been approved internally and you're confident about the proposal, then obviously sending that agreement with the invitation can save a lot of time. In more complex cases, you may prefer to have that initial discussion, which I think is always safe to do before issuing the agreement. So you kind of, you're erring on the side of caution, and you're just sussing out the situation before sending that agreement. So finally, just thinking about kind of timeframes. So the ACAS code recommends allowing employees at least 10 calendar days to consider the written settlement agreement. So you need to be giving them time to obtain that independent legal advice, which we know they have to do to make it legally binding. Giving them time to ask questions, Try and negotiate if you're open to that. Trying to rush somebody into signing is much more likely to result in an allegation of improper behaviour, which Hasti will cover later, and could undermine the protection that you're relying on. So we have to be really careful about the way we do it. Okay, so you're thinking to yourself, this is great, I'm going to kind of shed all the dead wood from my workforce, I can't be sued. What I would say is please stop, put a plan in first. So what does that mean? So we're going to consider the situation as a whole and look at the risk factors. All right. So is there a risk of claims? We often take all the facts before deciding on whether a settlement agreement is the right way forward. And it's very, like I've said before, it's a very fact dependent. So they're not suitable for all situations. Sometimes they're just not needed or could make that situation worse. So we just need to bear that in mind. Settlement agreements cost money to draft, all right? So there's that cost of legal advice for the employee going along with monies that you're offering to pay under the agreement. Is there an option here for you to follow a fair procedure to dismiss? Could this be cheaper? So, it depends, I suppose, on your appetite for risk. But, if you can save money and go through the process in the normal way, in the fair way, in the reasonable way, then, that's something to bear in mind. It would be cheaper. You also want to consider the wider impact on the workforce. Okay, so employees can sometimes, and I've had this before, become unnerved when people start to disappear without explanation. It's a bit of a culture of who's next. So and so was here last week and they've just disappeared, and a month ago so and so was here, just disappeared, and it makes everyone feel a little bit uncomfortable and on edge. So we want to be using a transparent process as much as we can, just for workforce morale. Obviously, these conversations are not easy and need to be done right. So you should not jump in without planning what you're going to say. Okay. Will the discussion be on a without prejudice basis? Will it be on a protected conversation basis? We need to be thinking about that in terms of, could it be, what are the risks of ET claims? We often draft scripts for clients to assist them because then, it's there black and white for them. They know what they need to say and don't deviate. You also have to be mindful that anything that you write down, the employee may request to see a copy of it because it could become part of disclosure, etc. So you should never tell an employee that they will definitely be dismissed anyway if they don't sign. There's always ways to suggest that an alternative option to signing a settlement agreement may be less favourable for them, but it's really important you get your language right there. So we can generally draft a settlement agreement quite quickly. So there are pros and there are cons as to when this should be done. So if before, so would you like the agreement drafted in advance of the conversation afterwards? So if before, this shows that you are serious and will add weight to the conversation. But then you've got to think about it. You will have incurred the cost of drafting the settlement agreement before you know whether that employee is going to sign. If it's drafted afterwards, this can drag out the process if the employee dithers and can kind of sometimes lead to quite protracted negotiations that you would not have necessarily incurred, got involved with had you offered it earlier. Sometimes it drags and slows down the process, and people are to-ing and fro-ing for ages on what they'd be prepared to settle on. So we also just need to think about, how is that employee likely to take it? Do you have a backup plan? Sometimes I'll have discussions on behalf of my clients, and my clients will be saying, I'm absolutely sure they're just not going to take it well, and I'm sure they're going to be very unhappy and get very upset. But sometimes you're surprised, and it's actually just all they want. So you just need to be mindful of the employee's reaction. So you just need to prepare for some upset, because sometimes they don't see it coming, do they? Because and they can think that things are okay, or working through things. So you just need to be really careful and think about that employee's personalities. How do you think they're going to be going to take it? Just being super prepared before you kind of introduce this settlement agreement or this offer is really crucial here. More for you as well as the HR advisor or the person having that conversation with the employee, because it can be very uncomfortable. So That's me. So I'm going to pass over to Hasti for some slides now. And she's going to talk to us about when is a good time to do it.
Thanks, Alex. So one of the most common trigger points is during a disciplinary process. So the settlement agreements can be a very pragmatic tool where an employer wants to avoid a long-running investigation, and particularly in complex, maybe misconduct cases, investigations can become resource heavy, disruptive, and very difficult to manage. There is also a reputational angle here. So if an employee was to be dismissed and then brought an employment tribunal claim, even if you're absolutely certain that you're going to be successful, and even if you are successful in defending the claim, the process itself can cause reputational damage internally and externally. So using a settlement agreement can provide a clean, confidential exit instead. Timing is key in disciplinary situations. These discussions often take place before a disciplinary hearing or before the investigation concludes. At that stage, the employee may have limited visibility of the evidence that's available, or there can be uncertainty around what the possible outcome could be, and that uncertainty can bring more willingness to engage in a commercial resolution. However, as a word of caution, I would just say that this shouldn't be used as a shortcut process, and this can't be used if there's no genuine issue or there's no genuine reason. There still needs to be a fair process followed, and there can't be predetermination or pressure in accepting a settlement agreement. The second scenario is redundancies and organisational change. So settlement agreements are often used alongside voluntary redundancy programs. I don't know if you've heard about, if I don't know if you've been through a redundancy process before, but often employers will offer voluntary redundancy, giving employees an incentive to leave on agreed terms while helping employers avoid compulsory redundancy processes. They can also be used to streamline the process, and in some situations, a settlement agreement can avoid or reduce the need for a full consultation, particularly in individual cases. Time pressure is often a driver where there is limited time to carry out a full and fair consultation process. An agreed exit can provide a practical alternative, although again, this needs to be handled very carefully. There's also an element of control here. So employers sometimes use settlement agreements where there is a genuine redundancy situation, but the consultation may not guarantee the desired structural outcome. Or where a restructure could otherwise lead to a dismissal for some other substantial reason. So, in those cases, a settlement agreement can provide certainty of outcome rather than relying on a process that could be challenged. But the key message here is settlement agreements should be a complement, not a replacement to a fair process. Thank you. So, another few examples of when is a good time. Another common trigger is performance management, similar to that example that we had earlier. So often this is before a formal performance management process has started. At this stage, there is usually a sense that the cards are marked. The employer may already have concerns that the performance is unlikely to improve to the standard that they require, even if a performance improvement plan was to be put in place. So, what a settlement agreement offers here is an alternative to what could otherwise be a very slow and difficult deterioration of that relationship. Formal processes can take months, can be quite uncomfortable for both parties, and often end in the same outcome. So it can be a more pragmatic and respectful route, particularly where trusting capability is reduced, the role is quite business critical, or there is limited appetite for a prolonged process. The next area is long-term absence. This is often where settlement agreements are used when an employee is unlikely to return in the foreseeable future. In these cases, the formal process can be quite lengthy. Managing long-term sickness fairly can involve medical evidence, occupational health assessments, ongoing review meetings, and sometimes the employee is just quite reluctant to engage in that process. So that can take significant amounts of time with no guarantee of a resolution. So settlement agreement can offer a cleaner exit. It allows both parties to avoid a drawn-out capability or ill health dismissal, and can help protect you from risk of a discrimination claim. And as Alex mentioned earlier, maybe the employee would actually be quite keen to take something like this, especially if they feel they're unable to return to work. Finally, one of the most practical uses is where there's been a breakdown in the relationship. These situations can arise for a wide variety of reasons. For example, there might have been a dispute between some senior employees, maybe directors or managers, ongoing interpersonal conflicts, a grievance that has now escalated and there's a lot of tension. And what makes these cases quite tricky is that there may be a clear loss of trust and confidence, but not quite enough for a fair and justified dismissal. And sometimes, if we're honest, it comes down to this working relationship just isn't viable anymore. And in those cases, a settlement agreement can be the most pragmatic solution, allowing both sides to part ways without forcing the situation into an artificial legal framework, trying to make it fit into maybe misconduct or capability or some other substantial reason, when in reality, it is just a commercial decision. Okay, so differences between a without prejudice conversation and a protected conversation. This is an area that often causes confusion, so it's worth being very clear on what the distinction is. Starting with a protected conversation, these are used where there is no existing dispute between the parties. They were initially introduced to allow employers to have off the record conversations about ending employment on agreed terms without needing to rely on dispute already being in place. However, the protection is quite limited. So the key point is that the inadmissibility only applies to ordinary unfair dismissal claims. So that legal protection of claims only applies to unfair dismissal. So that protection does not extend to claims such as discrimination, whistleblowing, or breach of contract. From a practical perspective, that means you need to be very careful about how these conversations are handled because the content may still be scrutinised in any other claim type. Now, without prejudice cases, by contrast, without prejudice applies where there is already an existing dispute, and this is key. So you cannot simply label it without prejudice and still get all of that protection. There must be a genuine dispute in place and also a genuine attempt to want to settle that dispute. Otherwise, that protection won't apply. The tribunals have been very clear on this point. So, on the case that's on screen there, it was made very clear that the crucial question would be whether, in this case, in the course of negotiations, the parties contemplated or might reasonably have contemplated litigation, if they could not have agreed to a settlement agreement. The EAT commented that with the employee's career in the balance while the school decided on the appropriate sanction, the employee would have had litigation in contemplation, mindful that he may have been dismissed. Therefore, negotiations during that period were protected by without prejudice rules. However, the EAT went on to hold that the negotiations which continued after the final written warning had been issued were not covered by the without prejudice rules, since by that stage there was no immediate prospect of an unfair dismissal proceeding. Therefore, litigation couldn't have been in contemplation, and that protection no longer applied. So the test is essentially, would both sides reasonably see this as a situation that could end up in litigation if a deal isn't reached? And without prejudice, there must not be any unambiguous impropriety. Proprietary. This includes blackmail, outright discrimination, and just unwillingness to actually want to settle. Once you've decided, next slide.
Sorry.
That's all right. So, what you could potentially offer, once you've decided to have that conversation, the next question is, what do you feel is a sensible offer and what does that look like? So, you need to take into consideration what is it that you're trying to compensate for. Start with the basics. Is it you're compensating for the loss of their employment, loss of notice, potential loss of legal claims, or simply an incentive to leave quickly and cleanly? Clarity here is key because it helps you anchor the offer in something rational and explainable rather than it feeling arbitrary. How much money or time will you save? This is ultimately a commercial decision, so you should be asking how much management time will this save? How much disruption are we avoiding by settling? And what is the cost of running a process versus settling now? Often, even a relatively generous settlement can still be significantly cheaper than a prolonged process or dispute. Rules of contract still apply. So remember, this is still a contract. For a settlement agreement to be binding, there must be consideration. And in simple terms, this means the employee must be receiving something over and above their contractual entitlement. Otherwise, there's no reason for them to want to settle. So you need to give them some sort of incentive to want to engage in this process and want to take that settlement agreement. What is the likely award and or defence cost in the employment tribunal? And this is where your legal risk assessment comes in. So consider what claims might the employee bring, what is the realistic value of those claims, and what are the prospects of them succeeding, and importantly, what are your costs of defending such a claim, even if you are to win the claim? Because in reality, employment tribunal litigation is extremely time consuming and costly. And settlement is often about risk management and not just about liability. Consider your tax status of payments. Don't overlook your tax position. Different elements of the package will be treated differently, so notice pay is almost always taxable. Termination payments may benefit from a £30,000 tax exemption, and structuring the offer properly can make a real difference to how attractive that offer might appear to the employee. And finally, are you actually prepared to negotiate? Because most of the employees are unlikely to accept your first offer. So you either need to go in with a strategy of what is your opening offer, what's the point that you're willing to walk away, and how much flexibility do you have in between. As a good settlement is rarely the first number that's put forward. However, if you absolutely don't want to budge, either you need to offer your max and stand firm, or start lower on the basis that they may ask for more, and it gives you some room to negotiate with a ceiling figure in mind. Okay, so payment in lieu of notice payments. This is an area that can often cause confusion, particularly when employers are trying to maximise the tax efficiency of a settlement package. Prior to April 2018, it was something possible to structure payments so that no notice pay was paid, notice pay was paid tax-free, but that is no longer the case. So the post-employment notice pay, or PEMP, rules were introduced to prevent this type of tax planning, and the effect is that the employee must always pay income tax and national insurance on the element of their termination payment that represents their contractual notice. So in simple terms, HMRC asked the question of how much of this payment is actually your notice, and whatever that figure is must be treated as your normal earnings would be and taxed through PAYE. For employees with a fixed monthly salary, and the calculation is relatively straightforward and is broadly based on basic pay times their unserved notice period. However, the legislation contains a statutory formula and can become considerably more complicated where an employee is paid either weekly or every fortnight, maybe receives commission, has variable hours or fluctuating pay, or has unusual contractual notice arrangements. So for those employees, I'd say it's quite sensible to maybe obtain some payroll advice to ensure that the correct tax treatment is applied. Once the PEMP has been identified and taxed, any genuine compensation payment can usually be paid under the £30,000 income tax exemption, provided it does not represent earnings or any other taxable amount. One point that employers often overlook is that notice can be served and worked, meaning the payment in lieu can be reduced because there is less unserved contractual notice remaining. So if someone was to have a 3-month notice period, maybe you could serve them their notice, they maybe work a month's notice, and then only 2 months notice would be remaining as post-employment notice pay, which would then be taxable through the settlement agreement. That should always be considered when negotiating the overall package. Similarly, where an employee is dismissed for gross misconduct, they would ordinarily have no contractual entitlement to notice pay, and in those circumstances, there may be no PEMP, although employers should be cautious. If there is any doubt about whether gross misconduct could be successfully defended, withholding notice pay may create additional legal risks and should be considered carefully before relying on it. If no notice pay is paid, but a compensatory payment is still made and is agreed, which would be tax-free, HMRC may see this as being PEMP, and it may appear to be tax avoidance. So that's just something you need to really keep your eye out for. The key takeaway is that notice pay is almost always taxable. compensation for loss of employment may still benefit from the £30,000 tax exemption. Employers should always distinguish between notice pay and compensation when calculating the settlement payments, and where the tax position is complex, payroll or other specialist legal advice should be obtained before an agreement is finalised. Thank you. So here are just a list of different clauses that could be included within a settlement agreement. So you've got your basics, such as your termination date, your holidays, pension, etc. And then you have things like restrictive covenants, confidentiality, making sure that no confidential organizational data is disclosed to anybody else following the termination, bonuses, whether they're a director and whether a resignation is required as director, entire agreement clauses, return of company property, company vehicle, any annual leave remaining that needs to be paid, and just sort of the general clauses that can be included. So that's more just for your knowledge to know what the settlement might look like. And so what happens next? So once the offer is on the table, the focus shifts to managing the process properly and avoiding common pitfalls. So in many cases, employees are placed on a paid leave to create some distance and protect the business whilst discussions are going on. Next, you need to set a clear time frame. So ACAS guidance suggests giving the employee 10 calendar days to consider the actual settlement itself. However, you can offer them 2 to 3 days in the first instance when you've only given them the provisional offer. So when you've just given them that initial offer to think about, you can give them 2 to 3 days. But once the settlement is actually drafted and they're looking at having legal advice, you would need to give them 10 calendar days to make sure that they've had sufficient and reasonable time to take advice, which helps support the validity of the agreement. For the agreement to be valid, it must be signed off by an independent legal advisor. In practice, that is usually a solicitor, and that solicitor would be advising the employee on the terms of the agreement and what rights they are giving up. Without that advice, the agreement simply won't be binding. So it's really important that that's done. And because that advice is required for it to be binding, the employer will usually make a contribution towards legal advice being sought. So historically, that figure was around £350 plus VAT. But in reality now, it's more commonly in the region of £500 to £750 plus VAT, or even higher depending on the complexity of the agreement. It's worth getting that right in the first instance, as if the figure is too low, it can delay or frustrate the process. The employee might also struggle to find a solicitor willing to speak to them or act if the figure doesn't quite match what the fee is likely to be. At this stage, you should fully expect negotiations. So very few agreements are actually accepted as a first draft. So you should be prepared for counteroffers on the compensation, requested wording changes, so any amendments that might be required, any reference changes, announcement changes, additional terms to be included. And the key is to be prepared and understanding what your parameters of flexibility are. The agreement only becomes legally binding once both parties have actually signed the agreement, and up until that point, either party can walk away or seek renegotiation. And finally, and this is important, and it just sounds a bit silly, but make sure payments are made on time. You would be surprised how many disputes arise because payments aren't being made on the dates that were actually set in the agreement.
Lovely. Thank you very much, Steve, for that. So that's our webinar in a nutshell. I imagine some of you have some questions. So yeah, just putting it out there. Anyone got anything that they'd like to ask? You can always follow up by sending us an email, and of course we can come back to you separately if you'd rather just not ask any questions in the webinar, which is absolutely fine. So just going on to a little bit of what we're doing. So we've got an ERA, so the Employment Rights Act, which I'm sure you've heard a million and one things about. 2025, we've got an ERA page on our website, lots of information on there, and we're always keeping it up to date. I would recommend scanning the QR code, and then you can download the planner to keep you, in the loop as to what's happening and when. So that's always something that's quite worthwhile doing. I'll just give you a minute in case anybody wants to do that. There's also lots of free resources on there, which are really helpful for navigating the changes and the reforms of the Employment Rights Act. Also, at the minute, we are offering Employment Rights Act training 2025 for training for managers. So if this is something that you think would be really helpful for your managers, please get in contact, because we can give you more information on what's included. It's on the screen now. But we've had quite a lot of uptake on that, and some good feedback. So please let us know if we can assist you with that. And then that's pretty much it. You know that we offer our watertight fixed fee solutions, and we do deal with all legal matters. Some testimonials there. And then, so feedback forms will be sent after the webinar to request a copy of the slides. So if you fill out the feedback form and you request a copy of the slides, that's how you'll get them. You have to fill out the feedback form first. If you enjoyed today's session, we would massively appreciate it if you could take 2 minutes of your time just to give us a little review on Google or Trustpilot or Review Solicitors. But yeah, that's it from Hasti and I in a nutshell. Thank you so much for attending, everybody. And I just hope you have a wonderful rest of the day. All right.